Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court. The fireworks are not done.
I was getting commentary as a kid. The Anglican
Is that correct?
Oh, from St.
All right. I'm sorry, I butchered the audio. I had filters on and everything, and now I'm getting a phone call. Oh, it's a spam risk. Hang on. Whoa. Hang on, guys. Hello?
Somebody just sent me a video.
Hello? 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 They wouldn't talk. Oh, well, never mind. We'll go back to the music. Guys, welcome back to the Court of Public Opinion. We almost had a spam call to kick off the afternoon session. It was close. All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. Did I forget to move or eat? No. I did not. It should have sounded like this, which has bass. I will tell you that there's a camera sitting right there that's normally not there, and with all the big trucks that are driving by on my street, the camera is looking up over my shoulder at these books. I think that's Anne of Green Gables. I zoomed all the way in, but so if there's a bug, it's zoomed in on the title of a couple books on the top shelf over behind me. Just playing with the zoom. We'll play with that some more. I've got the small remote working. I haven't plugged in the big remote yet. Okay, we have stuff. We have things. We have happenings occurring. And this is in the Bryan Kohburger case. Bryan Kohburger is, I believe, his defense team has filed a motion to basically dismiss the case. Like, look, Your Honor, look, this clearly isn't going to go forward. We're going to call it quits right here. You should just dismiss it. He's complained about everything from the grand jury, how it happened, improper. He's cited laws dating back to, I don't know, the 2nd century. It's I'm being facetious there, but he's thrown everything he possibly can at trying to delay this, and this might be the last little bit. I'm not sure if you caught Emily D. Baker on WLTV during the break. She was giving us some great analysis and takeaways on this regarding what's happening here. Why is that not working? That's a problem. Well, we'll use a different feed. Let's see. We need. Let's see. John Judge, Judge John Judge, is in charge of today's proceedings, and we're watching very closely for when his proceedings begin, because that's where we're going to go. Unfortunately, he won't let us use the bell icon. What YouTuber doesn't let subscribers ring the bell? Well, John Judge doesn't. So, okay, chat's not on screen. I forgot to move or eat, says Diet Coke Mama. No, we do have to welcome and thank Julie Fraser. Big shout out to Julie Fraser. You were re-gifted the internet under the rules of internet ownership, which have existed since before the internet began. There is a rule. There's a clause. It's like a sub-clause where the original recipient of the internet can re-gift one time. And each day, that's a possibility. And you were re-gifted the internet. Congratulations, Kim R. gifted you the internet. You are now the internet owner for today, Julie Fraser. For all intents and purposes, you are first in chat. Thank you very much for being here. Appreciate that. Just make sure the internet keeps running for everybody else. And we'll be good. Okay, we have 9 minutes. Let me tell you what's going to happen. Judge is not going to rush. He is not going to get the live stream running and get it going and then check the audio and make sure all the cameras are on and everyone good, thumbs up all around, everybody happy. A chat, can you hear me? It's not going to happen. What's going to happen is Judge is going to sit down, and once he sits down, his clerk's going to go over and sit down, and then she's going to go play with okay, let's Zoom. We're going to live stream to YouTube. Yes, today. Turn off chat. And then she's going to hit the go live button, and we're going to start mid-sentence with Judge. I'm sorry. I wish I could do something about it. But Judge, an audio or video professional, he is not. And we have to deal with that. We also have to deal with the issue where he will not let us zoom in on Bryan Kohburger. Apparently, that is a violation of his privacy, even though it's a public courtroom. And the law, as far as I can see, says if you can see anything from the public that doesn't have our expectation of privacy, which I don't think being in public court does, you can film it with some exceptions. Anyway, we won't go into that. So we are back. We're going to start with this as soon as it goes live. So I'm going to be I'm sort of between a rock and a hard place right now. So I've got to focus on this and just keep clicking the refresh button. It would also help if you click the refresh button and then let me know when we start. No zooming in. We will not zoom in. Will you do Karen Reed if it happens in March? Cricket, here's what I can promise you. No, I will not. And the reason why is because Brandy Churchwell is going to cover that one. She's been covering it already. She's done podcasts on this. She's done all sorts of deep dives. She's going to do an amazing job. She's a great friend of the channel. If you don't know who Brandy Churchwell is, type !Brandy in chat. That's just !Brandi. And you will have a response from my little bot here that will respond with the link to her channel. And it looks something like that. Brandy does a great job. She's going to be covering that case. We will be covering other cases. There are plenty. This year, we're loaded with good cases. There's good stuff coming. So we'll have a variety. If you want to watch the Karen Reed trial, which I want to watch as well, I'll be watching it on Brandy Churchwell's channel. There are some other great, fantastic YouTubers that have produced a lot of content on that, a lot of research as well. So lots of places to watch. Steve says, have a favor to ask, but then he didn't ask. I can't guarantee I'm going to see the next comment, Steve. I missed your comment from the last one. I will also say on the Karen Reed case, I'm not convinced it's going to go to trial. Let's see if it will happen at the end, says Angela. Yeah, I'm not convinced that it will be that we'll get that far. Steve N. I don't often do that, but that might take a super chat. I'm just saying. Just kidding, Steve. Go Chiefs! Go Chiefs! We're all about having no Indians and all Chiefs. No, who are the Chiefs, Steve? Who am I cheering for? I'm guessing it's not the 10 Little Indians and the Chiefs. I'm thinking it's a sports team, Steve. Go Chiefs! Yay, sports ball! Go team! I've cheered to the best of my ability. Tori, welcome from Scotland. Thank you for being here. We're super excited for that. We're excited. This what we're going to see today is most likely it's going to be a Zoom feed. Once again, it's a Zoom feed. We're hoping for good video and good audio because the judge controls this, and he controls it with an iron thumb. If you saw the thumbnail for this video, the judge put out an order about media coverage, and he literally ordered what people do with this video with their First Amendment rights down the road. It's not going to stand. I believe it's not going to stand, but I'm not going to be the one who challenges it. So we're going to follow the rules as best we can right now. Let's see. Where's... I don't want that one. Don't want this one. That one. Okay, there's... Okay, I think I'm good. All right, we're going to go right here. Okay, I'm just going to keep clicking the refresh button while I can. And then if you guys have questions, let me know. All right, it is hot as blazes in my studio right now. It is smoking hot, and I don't know why. It's if one of you could get with Weather Watch and have him lower the temperature outside. Oh, it's because it's 76 outside. It's a summer day. It's a midsummer day. All right. Either way, be it what it may, we are. Let's see, we're ready there, ready here. Where's my camera 3? I need camera 3 as a backup. Hold tight. Not this one, though. Not a police chase. We don't want to default to that. Driver crashes. Nope, not that one. Okay. Oh, we can always. Oh, not that one. Can always default to this. Okay, we've got some safety shots set up. I need like 3 more hands, and I realize I just told you guys earlier today that I'm super excited because I just got a new piece of equipment that comes with 59 more buttons. Looks like this right here. Well, you can't see that very well because, lighting. But trust me, there are 59 buttons on here, and they all do things I don't know what they do. I know what the joystick does, but the rest I have to learn. Not sure where it's going to go on the desk anyway, but it's going to control that camera over there. More and more buttons. All right. We're about 2 minutes from when court should start. I'm hoping he starts early, but odds are he won't, and he'll be late. And we just have to sit here refreshing until then. What is the camera for? Streaming? The camera, Daffy, is for streaming from a courtroom. We're setting up to be the pool photographer or the only photographer in some courtrooms, as the case may be. And I've been acquiring equipment as I'm able, a piece here and a piece there. This was a big purchase, so I don't get any pieces for a little while. But I've been acquiring cameras. I just got that tripod as well that it's sitting on. I just got the switcher or the controller for that. Really cool controller. If you're into the pan tilt zoom cameras, this is a PTZ Optics camera with a 30 power zoom. 1080p. I didn't go with the 4K because that was an extra $1,000 I just could not swing. And then got the controller for it that can control 256 cameras remotely over NDI. So good stuff there. No, sir, we got new toys. Yes, you guys get to benefit from that. I might set this up for a brief kitty cam, just so I can show you my cat, because I have all the equipment. I've got the wireless transmitters and everything, so I can do 4K. Well, I can't do 4K through that camera, but I can do 4K from remote location. All right. Any more questions? We're going to Katrina Hetherington. Thank you for gifting 5 memberships. Great to see you in here. Lots of memberships flying up the screen. I'm super excited. I am super excited for this. I'm also distracted, so I apologize. How annoyed is Mrs. R.A. every time you get new equipment? She probably doesn't like the price tags. Ashley, it's a business expense. I have to budget for it and plan for it and have reasons. It takes paperwork. This isn't something I can do on a whim. But I can tell you she's much more frustrated with the fact that every box that these items have come in is now stacked in my studio right over here. So yeah, I need to not keep the boxes, and then she'd be happier. Heather, you made it to a live. Congratulations. I have to fix. I think a couple people might have accidentally got put on the naughty list during the last one, as we had a couple trolls that tried to sneak in. If you did end up on the naughty list and you shouldn't be there, reach out to me a little bit. We'll see if we can get it fixed. I think we've got some that we're going to take care of right here. Wait for it. I have to click refresh again. Still nothing. Okay. The naughty list. Unfortunately, the naughty list is longer. There's the one. Boom. Fixed it. Save. Okay. If you know it was you, we fixed it. So thank you. The feed we're getting obviously is from Judge John Judge, JJJ. And we're sort of at his mercy, which I'm all for. As you heard from Emily Baker, she was talking on I forget where she was. She was on a TV news station on a little commentary this afternoon. We're all for transparency. We're also for cameras in the courtroom. But I believe it also has to be done right, because if you do a very poor job of it, it might as well not have any cameras in the courtroom at all. What is happening with chat? Katrina, you started, and then Coffee and Crime just gifted 5 memberships, and I think another 5 after that. Thank you very much for the gifted memberships, Coffee and Crime. Sorry, let me make sure I can see everything. Okay, I'm just gonna click, and watch for something. It is raining gifts. It's been raining gifts. A super generous day. So many people got memberships to this morning as well. I appreciate all of you. I appreciate the support. And I appreciate the way you support and help other people who are also, in this community, but it's just not in the cards for them to be financially to be a member right now. So thank you for helping that. WFLA, yes, I think it was WFLA that she was on. Okay. Emily DeBaker is phenomenal with what she had to say. She was on there with JB from WFLA. I think JB was a bit starstruck by having her on. I know they've been on before, but you know who the big draw is on that one. Okay, it is time. We're 3 minutes past. Judge on Judge, the feed is still not up. We don't know why exactly. Unfortunately, he's really locked down the controls in the courtroom, so live tweeting and everything else from the courtroom, it's just not going to happen. Joyful just gifted 5 memberships as well. Thank you very much, Joyful. The Brown Bard, I see you on that list. Jennifer White, Mary Beth Robinson, all great people. Great gifts. Welcome to the new members, and for those who have been members before and are now back, welcome back. What is expected today? This is going to be a motion to dismiss. So we're going to hear some argument probably from both sides. I don't believe the motion will carry, meaning I don't think the judge will allow the case to be dismissed. I don't think it's ending here. But I don't think we're ready for a scheduling conference. I don't think it's going to turn into a scheduling conference where we actually get a date nailed down on this one. We've talked a little bit about how that the judge probably doesn't want it to happen, and we heard this from Emily as well, that it doesn't want it to happen during the summer when school's in session. I'm hearing voices. I'm hearing voices, and I don't know what it is. Are you hearing the same voices that I am? Oh, it's on my phone. It's on my phone. Why is that happening? I had Judge Boyd going on my phone. Okay. Voices are gone. All right. Another membership gift came in from Nancy D. Thank you, Nancy D. I'd love to get a date so I can plan my vacation, says Zimmy, because you plan vacation around the trials you're interested in watching. That means you're a true crime addict, which is great. I've definitely been here all day, says Fairchair. I accidentally won the internet this morning, and you did a great job with it. Great job. Julie Fraser took over for you, so you can just rest easy this afternoon. Nothing to worry about there. Tough case we followed this morning in the Crumbly trial with Jennifer Crumbly. It's going to be a doozy as that moves on, but also a lot of strong personalities there as well. I'm going to let you look at this while we wait just for a minute. This is the amount that is owed by the J-Hatch, by J-Hatch to the Kowalskis. The top number is what they initially owed. The middle number is the interest that has accrued since then, and then the bottom number, as soon as I make this awesome message from Ohio Gin, who just gifted a membership, as soon as I make that go away, you'll see how much they owe there with the extra added to the original. Ohio Gin, thank you very much for that. Also, Greeners, another 5 memberships. I don't know why we have any people in gray at this point. The way these memberships are flying off the shelves. Interest every second. Well, Amelia, that's a great question. You've asked a great question. The interest does not actually accrue every second the way the judge made the order. There's a daily rate that will stay daily rate until it starts accruing daily starting January of next year. So the $51,700 something, I believe that is going to accrue every day until January, and then the formula switches a little bit, if I read it right. My son, who is much better at math than me, read that, and he formulated the whole thing from the original document. Georgianne, thank you for the super sticker. Thank you. That is super generous, and I love it. AWOL Podcast gifted another 5 memberships. You've been quite generous with your gifting today, AWOL. Thank you as well. Welcome to all the new members here. We're still refreshing. I've probably clicked 200 times since I started this. We're still refreshing to try to get the feed as soon as Judge puts it up for you. Let's see. Keith says, coffee for you and the mods. For working Saturday, you are the best. We are going to work Saturday because we have to catch up on the Crumbly trial. We're a day behind. We'll make that right, Keith, tomorrow. We'll be all caught up, and everything will be right in the world again. All right. Thank you. Natasha says, I just can't catch it. Make sure your gift setting is turned on. If you need to check it, you only have to do it one time. But if you need to check it, just type exclamation. One person, just one of you needs to type exclamation point gifts. That's gift with an S on the end in chat. And exclamation point in front of it, of course. And then click on the link that comes up. And that will, once it opens that window, you'll be able to move the slider to the right. That means that you are informing YouTube that you are open to receiving a membership should one be given to you. So that will make you eligible. Coffee and Crime, not done. Still just throwing gifts out there like crazy. Thank you, Coffee and Crime. Appreciate that. And MCAT, woohoo, what a fun year. 12 months. The logo next to MCAT's name, the orange courthouse, is a symbol showing that you've been here for 12 months. It turns orange at 12 months. So MCAT, thank you very much. It has been a very fun year. It would not be the same without you. I appreciate that. Appreciate the support. Appreciate you being here. And thanks for your generosity as well. Okay, we are still nothing from the judge. We're refreshing about every second. Erica 843, thanks for a great community. Thank you, Erica. 6 months there. Your courthouse just turned yellow. Thank you very much. Appreciate that and enjoy the yellow courthouse. It'll stay that color until it turns orange. All right, we're ready for Judge to jump on board. I'm willing to bet he forgot about the live stream. And this is frustrating because he says, I want to be the one that controls the live stream so nobody does it wrong. And then I think it's just as wrong for the judge to not air things so we don't know what went on as for somebody to air something inappropriately. They're like equal in my offense list. Could the judge post the live after it's done? He could. Instead, he deletes the live stream the second it ends. He went the other route, which is just awful. So we have to grab it while it's available or else it will not be there. And if you end up watching it late and you're like delayed, whenever his ends, he just went live. I think we're waiting for the video. There it is.
Let's get on the record, please.
Okay.
Okay, we are on the record. This is State of Idaho versus Bryan Kohburger, case number CR 29222805. We have Ms. Taylor, Ms. Logston, and Ms. Massa representing Mr. Kohburger. Ms. Mathis is remote. Mr. Kohburger obviously is in his courtroom. The state is represented by Mr. Thompson, Ms. Jennings, who is here also remotely, Mr. Nye, and Ms. Beatty. So we're here. This is an open case. You probably know we had a closed hearing this morning, and that was necessary because that was related to the grand jury, which is secret. So that's what that was all about. I'm assuming that you have all seen the amended order governing courthouse and courtroom conduct. We made some changes, and you probably also know that we are streaming now. And that is on a YouTube channel. If you don't know that, you can go to the Supreme Court, website, and you can get that channel if you don't have that already. So
that's what we're watching right now.
You don't want to be on a camera. You probably should leave. But generally, we can't see very well farther back in the courtroom. So just so you're aware of that. So today we are addressing reconsideration of the order denying motion to dismiss the indictment, and that order is focused on the claim of inaccurate instructions to grand jury. Also coupled on that is the potential for permission for appeal for interlocutory order. So, and a stay of proceeding in the case.
This would halt the case.
I think that's all the preliminary. Ms. Taylor.
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
I'm going to, I guess, be succinct since we argued almost the very same thing this morning. But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohburger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Logston. Mr. Nye.
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today. We need to get to a trial in this case, and that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first two factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate. It's time for a trial, Your Honor. Thank you.
Thank you, Mr. Nye. Mr. Logsdon? Reply.
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank you.
Excuse me.
Wow, some strong words there.
Well,
28 years.
First of all,
And then
this
takes
is a
a jab at the death penalty.
reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. As I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, and I'm going to deny the permissive nature of this. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court, denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it, refile it, as Mr. Nye said. So that's significantly more delay. So there's some other, actually, this is in a case law, Idaho versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
Do you want to go first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Lodson said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential fulfillment. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone is just simply appealing to raw emotion, and it has no place in this court. We would ask that that not be allowed any further. Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, and at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want you, Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as your Honor knows, we have two universities, part of our community. And during the academic year, we have graduations, we have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up and lodged. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session. So those are the considerations that we have, Your Honor. As I said, we filed this last month. At that time, and as we stand here today, we believe that we could be ready for trial this summer.
There it is.
Thank you, sir.
The state wants the summer. Let's see what the defense says.
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, counsel and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and counsel in support of that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and counsel recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Kohburger decided to waive his speedy trial. And the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order. And I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15 week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and counsel to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where
15 weeks,
there is the potential for a death penalty, we're looking at 2 tracks of trial. We're looking at the innocence phase where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury, what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards in capital cases. That's what this is. A death penalty case is a capital case, and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator, and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, as the court knows, everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Ms. Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those. Or 500 hours of high definition video, and we just have 1 of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just 1. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team have talked to less than 10%, well less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Bryan's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just a life story. We're required to go 3 generations back on each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We do have several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file and there's tons of sub-files, and I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case, and I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel, and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it, and we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have, and I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor. That is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the cast report. The court had ordered that we receive the cast report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then get them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue, I think the court's heard about this before. We've had bits and pieces of tips, and they've come in and we've reviewed them, but the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us, but they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Bryan. That's his right for effective assistance of counsel to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Bryan's our priority, but we are not going to be ready in June of 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohburger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohburger. I know different pieces, but I don't know where they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you. One more question. So sure. I understand this. I mean, I'm aware amount of disclosures already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
That's a tough question. If the state says you have everything, and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say, everything's going to go according to plan. I'm going to give you these deadlines, and all of the materials will be in the state's hands so they can give them to you. And the records you need will be given to you when you ask. And the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then I would say I could be ready by March of 2025. And that's me saying I'm going to spend every possible hour on Mr. Kohburger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team. But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you
that. This is priority for everybody, and I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time, so it doesn't come back. We can only predict the future so much. I only have so much power. So I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this.
Mr. Thompson is
getting things
the bearded prosecutor. He's also the one who's been coughing.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there. But you're right, all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them. And there won't be undue interruptions in the community that can cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And, I don't think that's going to change anything, Judge. When this case has national, if not international, attention. This spring, I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have friends in this community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case. It's not Moscow. It's not Latah County. It's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out, so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first. and not just rely on there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention Kohburger and said, "What are you talking about?" So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small.
It's tiny.
Lodgings aren't very good as far as a lot of lodging. But I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Lake Tahoe County.
It's going to be good, Toyo.
Yeah. Thank you, Mr. Thompson.
Phil,
So you're
need
saying,
your help.
looking at this realistically and the amount of information, evidence, non-evidence, that might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty, and that's painful. It's an everyday reminder, and they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once. That it doesn't come back on appeal, that it doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah.
They've both now said summer of 2025, possibly.
I want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible.
Need to set a deadline.
I'd really like to do this sooner than later. I mean, maybe March 2025, which Taylor, that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want a direct, certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality. And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions. Going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything to do it correctly, maybe we only have to do it one time. Because we don't want to do this twice. We don't want to do this 3 times.
Judge is kicking the can down the road a little bit, hoping for
no
better
matter
data.
What happens, okay, if he's convicted, it's going to be appeal. And that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain, the grief, because you can't really go forward with your life without this hanging over your head. So, I'm sorry.
There are probably family members in the
All right,
courtroom right now.
I'm going to contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently. And I want to do the right thing. Okay. So, does that conclude what we need to talk about today, Mr. Thompson?
I believe so, Judge.
Okay. Ms. Taylor?
Yes, Your Honor.
Okay, well, thank you all. We are adjourned.
So nothing really came from that ruling. And they're done. They cut the feed. I did a quick scan because interestingly, this case, the judge has put some rules in place for the video and how it's used. I did a quick scan of about 30 different channels that were running the same feed. And because the feed is available, it's free to everyone. I think there were like 7,000 people watching it live on his channel at one point when I checked, and about 30 channels that I could quickly find on YouTube. Only one of them was in violation of the judge's order to not zoom in on Bryan Kohburger. I only saw one. So interesting. A lot of people are taking that seriously. Here's what we got. This hearing. First of all, the first part of the hearing was a motion to basically put this on hold because of they want to appeal this. They want to see if they can get this thrown out, and it's still looking at the grand jury and issues related to that. The judge said no. That struck down. There was really no chance of that being successful because he had already previously ruled on this, and this was basically a motion to reconsider his previous ruling. So he politely listened to the argument, said no. The second part is the scheduling portion, where we were hoping to see some indication of a date. The judge there at the end, it almost makes it sound like he was expecting or hopeful for a date in the next few months, like 3-4 months out. Almost surprised at the requests by the defense to push this out so far. We've had the state wanting to do it during the summertime because of the logistics involved with the school and so many students and housing and the ability to bring all the witnesses in and put them up in hotels and the cost. And there's a lot of pieces that have to play to get together. And trust me, the state is going to struggle with housing wherever this is, whenever it is, because of the media attention. So many people are going to want to be there. So we heard the state say we want it in the summertime. This would be great, a summertime trial. Defense gets up and says, look, no, and they start throwing out numbers. They prepared just a stack of impressive numbers. We've got 50 terabytes of data. That's equivalent to, what did they say, millions of pages and 500 hours times 51 of high-definition video and 400 plus witnesses just for the innocence phase of the trial. They just threw all this stuff. They said there's so much. Plus, we still are just here in January, we got another 9,000 tips about tips that came into the police about this whole thing, and we have to go through those. Plus, after they made this huge list of it's going to take all this time, we need expert witnesses. We need their expert witnesses to tell us what they found, so our expert witnesses can challenge that. And so we still have to find those expert witnesses and figure out where we're going to go from there. There's going to be so much testimony, so much foundational testimony. They say, we anticipate, by the way, Judge, just so you know, it's not going to be a quick trial. It's not 9 weeks. We're looking 12 to 15 weeks for this trial, and it's going to be, it's just growing. And so with all this, we anticipate the soonest, the bare minimum for us, she says, summer of 2025. Push it out a year. And then she ends that argument with, by the way, it sure would help if we had more evidence. Right? And she doesn't, it's not that she wants more evidence. She doesn't want more work to do, but she wants a deadline put in place where the state where she can say, Judge, tell the state, at some point they have to stop dumping these bankers boxes on us. The DVDs, the files, the videos, all the stacks of paper, it needs to stop at some point so we can get to work. And if you could just set that deadline and say, look, state, you've got to, everything you're going to bring into this case has to be done by, boom, XYZ date. Set that deadline. Then once we get to that scene, we see what we have, then we can talk about this. And if possible, if you set the deadline, if it's soon, if they provide everything, if the witnesses talk to us, if in a perfect world, if everything goes great, maybe March of 2025, maybe. maybe March. And she says, even that, I hesitate to even, it scares me to say summer of 2025. It could be later. Anything could go wrong. There are so many motions to be filed. There's so much that's going to go on because we've got death penalty issues. There's going to be motions in limine evidence there's going to be a ton of motions happening pre-trial. It's taking her full attention. She is devoting her full attention. It sounds like this is the only case on her docket. This is the only case she is handling, and it is taking her full focus to bring this on. She is not being lazy. She is not dragging her feet. She's not just stalling for the sake of stalling to hope that the fervor dies down and maybe we can find a more favorable jury. This has a lot of information. She's not wrong, and the state agrees. She's not wrong. This is a ton of data. It's a ton. It's a big. It's a ton of tons is what it is. Is she a public defender or private attorney? I believe she's a private attorney, but she was hired through the public defender system. So it's a little convoluted. The gist of it is that Bryan Kohburger is not paying for his attorney, but she is the best of the best when it comes to what she does. And there are public defenders that are the best of the best. I'm just saying that she is a high profile lawyer that is standing in a public defender position. Anyway, so with experts, they haven't even found experts for some things. There are probably areas that they want experts in that they haven't even identified yet. And there's going to be all the motions for the court to grant that because it is a public defender from the pay side. It's a public defender case. All those motions have to be put before the judge and say, Judge, can we hire this guy? This is how much it's going to cost, and those will have to go through approvals. There's paperwork that before this can move forward. So no, she's not just whining. I would say she put her argument together very well. It was very well organized. It was accurate. I don't think there was anything in there that was inflating the numbers or the seriousness or the amount of work that she has before her. So I think it was fabulous. I really liked what she said, and it resonated with me. I wish it was sooner. I think the judge wishes it was sooner. The state almost suggested in their motion that possibly change of venue might be on the table for a number of reasons. Both the difficulty. I mean, they say that we're confident we can find an impartial jury right here in the county, Judge, and then in the same breath they say, and by the way, you can travel internationally, and all you have to say is Moscow, Idaho, and everybody knows about this case. Everybody says, "Oh, that's the college. That's the four college students, right? The BK." Everybody knows, but apparently he's still confident that in his own county they can find a jury that can sit there and impartially hear this trial. They're worried about space. They're worried about. That was an okay sized courtroom. It's not tiny. We've seen smaller, right? And but the space that they need with some 400 witnesses. Obviously, you don't need all of them at the same time. They would be scheduled out, 5 or 6 a week. Maybe a dozen a week. But the logistics of moving them and having them on standby and all your team and all the media and all the looky loose, there will be a lot. There will be a lot of people who want to be there and just hope that they can roll the dice and get into court that day, or they want to be there, or they want to tour the crime, the area, and they say, I've been watching this, I just have to see it for myself. The court hates that. But the fact of the matter is it exists. It's real. There's an interest out there. And so all of this is going to add together at the same time, and it will be impossible to find a room. It will be impossible to get a hotel. You'll be finding a room, 50, 60, 70 miles away if you're lucky, and paying double price for it during the trial. And so anyone who has a legitimate reason to be there in the area is just out of luck if they didn't plan ahead. So most likely rent an RV and drive it there. And pay somebody to park your RV on their back lot. I think that's going to be the secret. All right. Any more questions? See, Steven says, in summer of 2025, I'll be at 27 months as a subscriber. Steven, that is awesome. Thanks for doing the math on that. Ann is a public defender. Eliza Masoth is a private attorney. Jay Lodson is a public defender. Thank you very much. Ann Taylor is death penalty certified, and that was key. That's something they needed. MG, welcome to the gallery as a new member. Thank you so much for being here. I appreciate you joining us. Make sure you take a seat, type in exclamation point seat, and then help yourself to the emojis. Let's see. Don't get married in Moscow in 2025. I would say don't do anything in Moscow in 2025, especially if you expect guests to participate. I would not hold a party there. I would not vacation there unless you've really planned this out. Idaho requires 2 death penalty certified attorneys. Ariel, I don't know if the other one is or not. I'm gonna have to. Probably a couple of you could tell me better than that. I haven't dug into their resumes. Tipsy Gypsy, thank you for the super sticker. I appreciate it. Appreciate the super sticker. It's awesome. Thank you yourself for being here. All right, rent your house out. Oh, seriously, the locals, if they are able to rent out their homes and just leave, you see the same thing. It will be like Olympic level interest in the community. When the Olympics happen in a community, it's like the whole world just descends on it. I think even though it won't be literally every country from all over the world, the number of people that show up in the area will be very similar to what would happen if the Olympics were happening in that area. And so you're going to have, on a scale model, you're going to have the same demand on food, on services. Cell phone towers might be overworked, incredibly overworked. Coverage might be spotty. Grocery stores might see a huge demand for regular supplies that they normally just sell a moderate amount of. It'll be crazy. Does anyone here live in Idaho? Do you have a spare room? That's the question, right? Nova, appreciate that. Airbnb, those will book up now. Honestly, I bet you're going to see if they'll let you book out to 2025, which I'm not sure Airbnb does. The ones that do, people will start booking now just in case. They'll pay the cancellation fee on the chance they can save it now and maybe sublet it for a lot more money. It's one of the biggest cases in the last 15 to 20 years. It's huge. People, for real, think of all the people that found out about this case because it literally spanned from the one side of the country to another with as we followed him, as police followed him without our knowledge from college back home, and then as we all followed him from home back to Moscow, Idaho. A lot of people got this on the radar, and it's not going to go away. Adam says, I sent a picture to the burner about tomorrow's stream. I'll take a look at that. Thank you very much. I've got a call coming in on the burner phone right now. Let's see who's on there.
Call from Nosy Rosie.
Nosy Rosie, how are you doing today?
I am so great, and I have loved being in chat, and I'm understanding how the whole calling in and turning down the volume works. So I'm actually completely away from
Wonderful.
noise.
What's on your mind?
So I have a couple things on my mind. Number one, happy birthday, little miss.
Yes.
This is for you, girlfriend. Go Lions! Go Lions!
So we had a Go Chiefs and we have a Go Lions. Are they playing each other?
I think so. Okay. I know little miss was like not having it earlier with Steven. Yeah. So, Steven, we're still cool though, right?
Of course, we're all friends, even if we cheer for different teams on certain days.
I have a couple things.
Mm-hmm.
I think that the judge is going to push it out. It's a huge case, and the victims and families do need. I don't like the word closure. I feel like resolve. Because I don't know if that closure actually is fully resolved.
Yeah, we can't sit here and say this will bring them closure once this is done. It doesn't.
Never.
And they're the only ones that can say if there's a measure of closure that's been achieved with a verdict.
Yes.
But we do want to offer them that. I mean, it's
yes.
painful to see a family who's suffered and continue to be dragged through it, right? Because until
yes.
this trial's over, everything's rehashed on the news. I mean, we talk about everyone who's seen this case. How would you like to be
yes.
one of the victims' families, and you go home and you
yes.
just want to relax, and anytime you turn on the TV or the radio, your daughter's face shows up, and there's discussion about the latest motion of the filings and what's happening. It's going to be devastatingly it's life-changing. It's hard on families. It's hard for families to stay together through this.
The reality is that for us as spectators, in a way, and I'm not going to lie, it kind of is like entertainment, and it's wrong. Yes, I've learned a lot about the law, and that's the great part of it. I'm in a community with a lot of great people, but I'm just an observer, and I am not emotionally attached in the way that they are. So it's hard. I think it's going to be summer of 2025. That's the one thing. The other thing is, if it's going to be a 15-week trial, do you think that they will sequester the jury? That's a long time for jurors to be exposed.
I tell you, this is a huge trial. Usually you think a big trial, the odds of a sequestered jury is higher. But when you go that long, you're asking them to not see their family for a quarter of the year. You're just going to be like, hey, sorry, civic duty calls. Just put your life on hold. And whatever happens with your family, we just can't risk you being exposed. Because 15 weeks, I mean, how many alternates are you going to have as well? I mean, how many is enough?
OJ.
It's going to be crazy.
Yeah. The other thing is that Jax and I have a quick get-rich-quick scheme, and it was to buy a house, a trial rental house, rent it out for like super expensive per day or whatever. And then I thought, oh my goodness, RA and all the little RAs are going to need a place to stay. And I can't charge like $1 bajillion a day to the little RA family.
I'm just going to there goes the quick. I'm just going to bring my hammock and pay somebody $100 a night to hang it in their backyard and just call it good and hope it doesn't rain. Is that a plan?
Well, okay then, that's fair. I'm you know what? You could stay in the master closet. Yeah. How's that?
Yeah. No, we joke about this, but there is a thing called grief tourism. There are people who want to be there and see it for themselves, and maybe don't have any other connection, and they'll be going, and there are people who know that and will try to. I mean, it sounds crazy, but I would I'd put money on the fact that there will be people in the corner selling trinkets and mementos and souvenirs for this case. It's that big. People see opportunity, even though it's a loss, it's hardship, it's a tragedy for those for the school, for the community, for the families, and they'll try to capitalize. And they're going to do it in the homes, the what you call it? What's that? Is that for me? Okay. Oh, awesome.
Can we get another package? What is it?
No, it's
unboxing.
It's a company thing for my accountant. So it's paperwork I have to do.
Put it back.
Yeah, send it back. But there are going to be people literally that will probably build homes or make accommodations available just because of this trial, because it will be that lucrative.
Again, seeing like the both sides. Yes, making a buck. But we're also making a buck off of the victims. It's such a double-edged sword. Trying to be a responsible person, and I have to say that whatever feelings I have or we have towards the defense, and even going back towards Tucker and his personality and whatever. At the end of the day, we are all entitled to a good defense. It's one of our beautiful rights in this country, and we may not like it, and we may not like the verdict, but the defense attorneys are working for their client, and we want to have the best representation for ourselves if we were ever to be in that situation. And with all the media, like we're all, Kohburger did it, he did it. We saw all this stuff. But we're supposed to go in with the presumption that he's innocent. And that's really hard to go into with all that we've been exposed to. And so the jury is going to be...
It's going to be difficult.
It's going to be hard.
Seating a jury is going to be extremely difficult. And I imagine everyone's going to get a letter. And the whole county is going to be down there. And they're going to scour through people that and try to find people. Because this is not something you want to try to do again because, you find out halfway through that a juror just, I knew he was guilty from day one. That's like, great.
Well, look, think about this. You cannot, at this point, be on social media commenting on how you think that BK is guilty or your feelings because all the jurors will be getting scrutinized.
Oh yeah, the investigation will go into in the jurors. That's going to be serious. They're going to ask all sorts of questions and and you think you might be able to say what you want now, and then later down the road be able to be somebody else. It will come to light. I tell you this. There's too much at stake.
Juror 1 brought a lot to light, and
he
people
did so well.
pay attention.
Yeah.
Mm-hmm.
Yep.
Yeah. Anyways, I will let another caller have a chance. It was great to see you, and I am all in for the maple bourbon pickles. I love them now.
I've got another
cold
believer.
Chilled is the best.
They're good cold. Thank you so much, Nosy Rosie. Appreciate the call. Good talking to you.
Have a great day.
We'll see you.
Bye-bye.
Bye. All right. I'm curious what you guys are thinking. I'm curious about change of venue. I mean, for me, when I hear change of venue, it doesn't make a huge difference personally, right? If I'm there, yes, I'll be staying somewhere else. But for me personally, it doesn't matter if it's in courtroom A or courtroom B. It's just, it's not a big deal. The thing that will matter, I think, if we do a change of venue, we go from the courtroom where the judge is in control and knows everything to an unfamiliar courtroom, and it could actually change and impact the way the video is covered because the judge has ordered that courtroom is in control, that they're going to live stream it. If they go from this courtroom to another one, it will probably be a bigger one. There's a chance that the courtroom video system is better, we have better cameras. The mics today were great. If we have this all the way through trial, I'm like, I'll take it. But there's a chance that it could impact the quality of the feed and the what we have available to us if we have a change of venue. All right, people out here saying BK is guilty isn't right. Nothing has been proven or even provided, but people want to convict him based on arrest, which is crazy to me. The system is broke. They need to be able to set it aside if they want to serve on a jury. I think they have to change venue, says Song Chef. It's a tiny community. It can't hold what is coming to it. Does Judge go too? Yes, he does. He becomes a guest judge in the other venue. So he goes, the prosecutors go, the players remain the same, but they move to a new courtroom. And they move to a new, oftentimes they'll take the same bailiffs. Have you seen that? The bailiffs will travel with the judge. And they might have some from both. Did I read the RA is streaming tomorrow? Yes, we are, Aunt Candy. We're streaming tomorrow because we have to catch up. We have to catch up on the Crumbly, Jennifer Crumbly trial. We're a day behind. So we'll be doing that tomorrow. Probably starting between 8:30 and 9 o'clock. That's the idea. Somebody asked if my package arrived. Yes, I did get my package. Let me show you. I've got the camera turned on right now, and it's zoomed in. It's zoomed in to a little tiny emotional support zebra that I have hanging from my microphone boom. It's shaking right here because I've got the fan mounted on the camera as well. So, it's leaning against the camera. So the fan is shaking the floor and the camera is shaking. We'll get that fixed. I haven't added yet the tripod weights to load everything down. No, if you turn it off, I'll die from the heat. That's all right. Thank you, though. Let's see. What time tomorrow? Between 8 and 9 o'clock. Ellie Moose, welcome to the gallery. Thank you. Green Courthouse by your name. That means 4 months of support. Thank you, Ellie. It would have been the same without you. Appreciate you being here. All right, we are... Blame the client, not the lawyer, simply said. Let's see. Is there anything else we need to cover? I don't think so. We're going to work tomorrow, so I wanted to get a little bit of time off tonight on a Friday, give you guys a little bit of a break. The zebra is courtesy of Reverend Beasy, who also exercises for me. He ran like 2.5 miles for me the other day, so I did not have to. And what a kind guy. Appreciate that. You mispronounced Chiefs, Steve. Love it. Go Chiefs, Steve. Go Chiefs. That's from me. All right. Let's wrap this up. Do we still have your spicy peanut guy? I'm looking for him. This guy? Is that who you're talking about? Of course I've got him. He can't leave him. Tonight, Rob's on Friday Night Frenzy. If you don't know who Rob is, Rob from Law and Lumber, one of the pillars of LawTube, if we could call him that, one of the pillars of LawTube. A great guy, good friend of the program, and an amazing, smart lawyer as well. I don't know what he's covering on Friday Night Frenzy. I'm thinking Ian will be on with him. Ian's back from his Las Vegas stint. If you didn't follow Ian on Twitter during his trip to Las Vegas, you were missing out. Runkle of the Bailey, great channel. Some good stuff from him. He's a comedian. Always has funny things happen around him too. So you still need to catch up on Law Talk with Mike. You need to check out Rob. They picked a mediator in the Maya case. That's news. That's going forward. Mediation. That's good because even as they speak, interest is accruing in the Maya case. The numbers are going up.
Do you not refresh the page? The website's down.
No.
But it's accurate right now.
My son says, don't refresh the page. The website's down, but the numbers are still accurate. So that's the Maya numbers. The top number there is how much the original judgment or the original amount was that the jury returned. The middle number is how much interest is accrued since then. The bottom number is the new total. So give it a couple more days, and we're going to see that 208 roll over to a 209. But good stuff. All right. We've been here it's been a long day. My mods have been working overtime, and I didn't warn them. And then I didn't warn them we were going to do this extra stream today, and then I told them we're working tomorrow as well. So they need some time off, and we need to. Adam says, check the burner. Let's see. Adam sent an image. Let me see if I can show this image, Adam. Nobody call the burner phone right now for just a second. Okay? I need to put it on the airplane mode so nobody's number accidentally appears on the screen and I accidentally dox them. Let's show it this way. I'm going to need you to come in on Saturday, so if you could be here around 9 a.m., that would be great. That doesn't show up really well on that camera because it's screened out, but I love it. We're gonna use that for the thumbnail tomorrow. Is that all right? For the Crumley trial. Do we have an update on Sarah Boone? Yes, it's going to be in May. That got pushed out. They have expert witnesses that need more time, and so it's going to be later on. Unfortunately, we thought it was going to start the end of January. It pushed one more time. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow, Saturday morning, sometime between 8:30 and 9. First person in chat, as usual, wins the internet. All they have to do is just be the first person to type anything in chat. Not the word anything, but type anything. And they would be the winner. And then they would be the winner of the internet and maintain it all over the weekend. So if you want that to be you, make sure you click the subscribe button and ring the bell. You guys be good to each other. It's been a fun day. We'll see you tomorrow. Bye.
Because he's the guy.